Hear ye, hear ye, hear ye. This court from recess now sitting.
Thank you. Please be seated. Turn now to the third case on this morning's docket. That is case number 105483, State of Kansas v. Dean J. Boleyn, Jr.
Thank you, Your Honor. Good morning. My name is Randall Hodgkinson. I'm representing Dean Boleyn this morning. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, I'm primarily planning to talk to you about the first issue, the trial issue in this case, and would submit the second issue on the brief, except as the court directs otherwise. The first issue in this case has to do with the introduction of some evidence, in the end, evidence of Mr. Boleyn being in possession of some homosexual pornographic materials, along with some others, but that's the main subject that we're dealing with here. And so I just wanted to take a little time to get at how we got there in this case. As the court's aware, this is an aggravated indecent liberties with a child case and involves allegations against Mr. Boleyn by his fiance's son in this case. And so as is typical, well, or at least common in these kind of cases, there has to be sort of an explanation given of why would somebody have sort of made these allegations, and the explanation in this case had to do with discord in the relationship between Mr. Boleyn and his fiancée. And the state started off sort of explaining this discord and introduced this topic.
Well, now, let's start at opening statement with the state saying nothing about sexual preference or anything like that. And you're, Mr. Boylan's attorney in opening statement, making some sort of proclamation talking about homosexuality and then saying he's not gay. I mean, it's right at the outset. They're the ones, you're the one that kind of put it out there, at least at the outset. So doesn't that kind of set it up, at least there? And I understand what happened in the state's case in chief with the victim's mother. But wasn't that just to kind of it wasn't highlighted, it was just kind of an explanation as to, what's going on in our relationship. Are you gay?
And Your Honor, it's and from the evidentiary standpoint where this starts, when the state brings out the information from the mother in this case and says, can you tell us about the demise of your relationship in his terms? And the fact that she says, I asked him if he was gay, and he said he was not. I don't think any of that's particularly objectionable. That's not where our objection is.
Okay, so
the idea that the circumstances surrounding the discord in the relationship, I think, is relevant, and that's not the objection.
Okay.
And I think counsel foresees that that's going to come out and that it's not objectionable. And it's not our objection.
Okay.
But from an evidentiary standpoint, the state does bring this out in their case in chief, this allegation by the mother that Mr. Boleyn is gay. And
it's not really an allegation. She's exploring.
Supposition.
Exploring what's the reason for, there's no intimacy between us.
Right.
I don't understand. I'm trying to do this. Are you, and that's really not an allegation. It's an explanation, as you say, of what's happening in our relationship.
What's happening? Yeah. But it is, from an evidentiary standpoint, the state has put this out in their case in chief. And so certainly my colleague is correct that in defendant's case in chief, then the defense attorney directly asked Mr. Boleyn, are you gay? And he testifies that he is not. Now, the state has taken this situation where this area has sort of been opened by the state, and the defendant has responded to it in the very limited and specific fashion to say no, to answer that question out there, at least that's sort of been raised, and then said, well, now the door is wide open. We want to bring in this evidence of pornography. And so that's the question before you today. And it is our position that nothing that the defendant did in this case opened the door that made the question of Mr. Boleyn's sexuality material and evidence, therefore, about his sexuality relevant to the issues at case, whether Mr. Boleyn engaged in the illegal acts in this.
Right. And in fact, it's not relevant.
It's not relevant.
It's not relevant.
Sexuality is not relevant. And I know my
But the point is that your client made it relevant by the emphatic denial.
He didn't make it material, though. All he's doing is responding directly and specifically to what the state brought out first in their evidentiary portion of their case. And we should be allowed to do that without sort of swinging open the barn doors to all sorts of prejudicial information.
So 2 wrongs make a right. I mean, if it's not relevant, the response is to argue that's not relevant. To object to it, and even if it's allowed in to argue to the jury, that's not relevant. It's not to make it a disputed fact by taking the stand and emphatically denying. You follow what I'm saying?
I do follow what you're saying, and I disagree with you that it makes it a disputed fact, a disputed material fact, by doing that, as opposed to responding. 2 wrongs don't make a right, Your Honor, of course, although, to some extent, under the opening the door doctrine, when one party brings up a topic of inadmissible evidence, it allows the other party to address that. We often see this in the other direction, but allows the party to address that. But, Your Honor, you open the door only as far as it's open. It doesn't say, once you open it a crack, it's open as wide as possible. And that's what it seems to me that the district court allowed in this case.
I was just going to ask, I think it was Justice Rosen who asked a minute ago, it appears as though during the opening statement by defense counsel, he is assuming, maybe because of something he had read or heard from the state, that they were going to make this an issue, and so he opens at least a tiny door saying Dean Boleyn is not gay. So it proceeds then for the state to put on evidence suggestive of that, and then there's a counter to that by defense, no, I'm not. And it just looks like a lot has come through the door here. So I'm just asking you, are you saying evidence confined to whether he is gay or not would be fine, but when you start talking about these materials, that's beyond being gay? Is that where we are? I'm just trying to figure out what your argument is.
That's my job. My understanding of this issue and my argument today is that it's, I think, clear that defense counsel anticipated that the state was going to bring up issues about marital discord, and in fact, that's not objectionable. The evidence of marital discord is not objectionable. But by bringing out that evidence, it's only material and relevant for the purposes of establishing marital discord, not establishing Mr. Boleyn's sexuality.
Why is it not material to prove he was lying? Why doesn't it become material because it's an impeachment of credibility if he's lying?
Because it's not, the fact itself that you're dealing with isn't material.
But that's often true in impeachment. Often when you're trying to show, don't believe anything this guy's saying because we can prove on this point he's lying to you. That can often be a fairly tangential fact, but it establishes, but is material to the overall credibility of the witness.
But if the fact itself...
And I understand it becomes more sensitive here because he happened to lie about a very sensitive topic. But would you be, but we allow that's kind of a lot of what the open the door policy is based on, is that if you open up something where we can impeach you and show you lack credibility on that topic, you're the one that's opened that door.
Okay. I think I'm getting this, and I hope maybe this gets, it will be crystallizing it somewhat, is that we understand that when the state brings up this topic, and one that we don't think is particularly, in bringing it up, objectionable, that it opens the door maybe to some other evidence. But the idea is that the opening the door doctrine should be limited to evidence that's material into that question. And there's no finding or no ruling or precedent for the idea that, well, except impeachment evidence, will open the door up as wide as possible for impeachment evidence, especially this very prejudicial kind of.
Actually, I think that we do have some cases that say, once the defendants open the door on impeachment, it's pretty wide open.
I'm not conveying it correctly then.
You're saying that the evidence that he possessed homosexual or possessed electronic files that contained images that convey homosexuality is not material to whether he was gay or not. Is that what you're saying?
No. I'm saying that whether he's gay or not is not material to the question that was before the jury.
Not whether he was molesting this child.
I think we all accept that.
Right.
And that, therefore, the state should not be able to open their own door on a question that just by bringing up the issue of Mr. Boleyn's sexuality is inherently prejudicial on some level.
So the state should have admonished their own witness not to give the facts or circumstances about the discord in their relationship.
Possibly,
or at least that fact.
Possibly. Or where we're really at today is that Mr. Boleyn should be allowed to respond to that without completely opening the door to sort of unfettered prejudicial information. That's really what we're getting at. That the bringing this up and evidence of the marital discord does not make it so material, and even then impeachment on that point still not so material that it becomes a
And then let's get to Justice Johnson's, I think it was his question about whether or not possession of pornographic material as stipulated to is proper rebuttal. Let's just, is it and I know there was a stipulation they agreed to let it in, but is it even proper rebuttal to allow that? I mean, does that rebut anything?
You don't have to be gay to possess this sort of porn.
Exactly.
Yeah,
that's what I mean. That's my question.
Is it probative at all? Is it
I
relevant?
might be accused of being a Muslim, and I would say no, I'm not. And then there's a Quran on my bookshelf. Does that mean anything? Maybe I know it's different, but that's what I'm.
No, I mean, there's obviously a lot of reasons that people can possess any number of sorts of information. I'm just, I just wanted to be honest that I know the standard of relevancy is pretty low.
Yeah, I know it's abuse of discretion. Let me ask you one more thing. Is let's say we say yes, you're right, Mr. Hodgkin's error. What about doesn't this case really hinge on the admission of and which isn't objected to, the admission of the recorded conversation between the victim and your client? Pretty damning evidence there, in which they talk about touching. I was pretty descriptive. It's wouldn't that evidence overcome any error that's here?
And so the suggestion is that this would just be harmless error.
Right.
I mean,
how would you?
I guess I think when you look at the totality, which as you've indicated you do de novo on this kind of analysis, when you have a situation where there's no physical evidence, and when you have when you even have the jury seeming to have some pretty strong problems with the strength of the state's case.
Well, not on the one allegation where I think the conversation that's recorded appears to deal with a touch, and they found him guilty on that, and that almost cuts against you in the sense that, well, they did take this seriously. They did look at all of this, and this supports one charge.
I understand that argument, but, Your Honor, I don't think. I think when you have a split verdict like this, it shows that the state has put on a lot of things, and it's difficult to know which part of the evidence would have tipped them from, saying acquittal on the whole thing to conviction on the whole thing, or some other permutation of these things. And so I think when you look at the total circumstances, particularly the lack of physical or medical corroborating evidence, that if this was brought in, that this would have been important to the jury, and that you would have a difficult time saying there's no real probability that it didn't.
I'd like to go back to something I think was implied a few minutes ago, I don't know if it was a direct answer, what do you regard as our standard of review on this issue?
On the
evidence.
harmless error or the...
Yes. The admissibility of this evidence. How do we review that?
I think it's de novo, because you're primarily dealing with the decisions of relevancy and materiality.
The materiality prong of relevance. That's what you mean, right?
Yeah.
Very good. Thank you. Any further presentation?
I just want to ask whether or not your allegation is that the pornography was either a civil wrong or crime. Are you looking for a 6455 analysis of that evidence? I didn't necessarily see that that was the way it was argued.
That's not the way it's argued, and that's not the analysis that we're putting forward. The idea and the citation to Blomquist, the Court of Appeals Blomquist decision in this case, isn't that it's prior bad act evidence, because I don't know that it necessarily is.
That was.
But there's a risk, and it's recognized in a lot of the cases cited in Blomquist, that jurors will draw a negative inference from this. Now, whether there could, it hasn't been raised this way. I mean, maybe you deal with this could deal with this in a limiting instruction situation like 6455 to deal with the prejudice that potentially comes out of this kind of evidence. But that's not the way we raised it in this case.
Any further questions of counsel? Thank you, counsel.
If it please the court, Keith Schroeder, Reno County District Attorney, on behalf of the appellee in this matter of the state of Kansas. I was trial counsel. I was also trial counsel on the 6 cases that the defense brought up on the proportionality issue of the constitutionality of Jessica's law, and the second issue, which I'll submit as well on the brief, so I was familiar with those facts. But in this particular case, I guess, first of all, there was some issue about what the standard of review is. I believe it's abuse of discretion. I believe it's the admission of evidence. Lies within the sound discretion of the trial judge. This is a case in which the state tried very hard not to bring in evidence of the possession of child pornography by the defendant who was charged with sexual abuse of a male child. And this was male child.
You tried real hard not to bring it in, but then you did bring it in on rebuttal, and what did you hope to accomplish?
Actually, we didn't bring it in on rebuttal. We did not. In fact, we were given permission to bring it in on rebuttal. But instead, I met with defense counsel, and we crafted a stipulation that specifically excluded the fact it was child pornography. I just referred to it as homosexual pornography. It was child pornography, but we tried very hard to obey what we believe to be the edicts of this court with regard to the admission of that in those situations and the prejudice that they could provide, even though the court gave us permission to do that. And it would be a whole different situation if I was up here arguing that, and I would still be arguing I would be right by having introduced evidence that was child pornography, but we didn't. We backed off of that and just admitted it as homosexual pornography. There was some statement about the state having brought in the issue of marital discord and the question about whether it was really relevant or material. It was relevant material for several reasons. One, it was the defense. That was the defense. This is a false allegation that was born of marital discord, a problem between the defendant and his wife that boiled over to her oldest son making allegations of child sexual abuse. That was what the defense tried to say this was. The whole case was about marital discord. And then furthermore, it goes to the interviewer bias. Remember, this child kept this to himself. And ultimately, as the result of his mother viewing some texts on his phone from the defendant after they were separated and having some concerns about what she thought was unhealthy continued contact and a close relationship with her son, and she looked at these texts and she confronted him and she said, "Is there something going on that you want to tell me about?" And at that point, he disclosed to her. We had interviewer bias all over the board here when it comes to marital discord. Those were issues the state had to bring up. Now, I'll keep in mind that when the mother was testifying in the state's case in chief, she was specifically asked, when she wasn't asked, she volunteered. She said that she confronted him about being gay because of a non-existent sexual relationship and the deterioration of their marriage. When she asked him if he was gay, he said no. That's the end of the story. He said no. There is no reason.
But counsel, it's not the end of the story because you asked the next question. And the next question you asked was, how did he react when you said that? She
said, no, I don't think so.
Right.
So,
but didn't you ask the next question?
And I can't recall.
In the exchange. And so.
How did he react? And
your question's generic. Tell us about the demise of your relationship. And then then the witness goes on and talks about, well, we had problems in our sexual relationship. It was non-existent. I asked him if he was gay because I didn't know what was going on and what was wrong. That's the part you talked about. The next question you asked was, how did he react to that?
I don't recall her answer.
And so then she says, well, his exact words were, no, I don't think so. And then you asked, did he get angry about that? No, he didn't. So, I mean, it's not quite as, I'm not saying it's, I'm not trying to take you too far with this. I'm just saying it's not quite as benign as the witness volunteering it and then you trying to move across the courtroom to a different subject. But still, you hit on the subject.
And I understand what you're saying, but still, what's out there is, I'm not gay. That's not out there. There's no reason for the defense to ask that question again, to say, are you gay? The state did not follow up at that moment and say, Judge, we'd like to introduce evidence of this pornography that was found at that point. It was left. It wasn't until it was just a straightforward assertion by defense counsel when she specifically, and the transcript doesn't give you the influx of the voice and the drama in the courtroom and the pause that happened before and the, are you gay? It was a very
Mr. Schroeder, if we accept your point that the end result of whatever questioning occurred during the state's case was that he had said no and that he wasn't angry to be asked, making it about as unprejudicial, I guess, as it could be, and that the defense really didn't have they shouldn't have mentioned it again. They should have just let it die there. I think that's the point you're trying to make. If the defense question was just superfluous or unnecessary or whatever, then why did the state need to bring in the pornography?
I think if you look at the surrounding facts that were going on at the trial at that moment, the state had rested its case. It had presented the evidence, the video or the audio recording of the phone calls. Mm-hmm. Now the defendant's on the stand giving a complete different kind of version about the deterioration of the marriage and the problems with his ex-wife over a check, and kind of leading up to the marital discord is the reason.
But the reason the porn was introduced or sought to be introduced was because he said he wasn't gay. That he opened the door during his examination in his case, right?
It was relevant rebuttal. That's the state's position.
What did it rebut?
It rebutted the fact that he testified he was not gay. In his possession is homosexual pornography. That I acknowledge that may not absolutely convince people he's gay, but it's still relevant. It's still material that you leave that up to the jury to determine.
Is it material? Let's talk about the difference between material and probative. I'm questioning whether it has probative value right now, and you're saying, oh, you think it does. Okay, so that's an abuse of discretion standard. Materiality is not. It's de novo. And how is it material to your case whether this man was a homosexual? How is it material?
It's rebuttal. I guess that's the point. Is if he says under oath, "I'm not gay,"
but how is that fact?
He is gay.
Excuse me, sir. How is that fact material to your case? How is it material to your case? What the allegation is that he's molesting this child, that he's behaving as a pedophile behaves.
If we're dealing with the 6455 analysis, I understand that. I'm going to go back to my brief.
Well, we're not. We're not dealing with 6455, but I also don't think you've argued that it's just pure impeachment of his credibility because he lied about something. How is the fact of his sexual orientation material to your case? That's my question, because I think that question we have de novo review on. And I'm eager to hear what you have to say about it.
I guess my understanding of the admissibility of impeachment or rebuttal testimony or evidence isn't so much about materiality. And I cite the rules with regard to admission of it on page 8 of my brief. It's dealing with whether it's probative evidence and unfair prejudice. They talk about to render evidence of collateral facts competent, there must be a natural, necessary, or logical connection between them and the inference or result which they are designed to establish. And it doesn't need to directly bear on them. I mean, when you look at those rules of law dealing with, I don't see the materiality prong of rebuttal evidence.
So rebuttal evidence doesn't have to be relevant?
It has to be relevant. It has to be...
Well, materiality is a portion of relevance. That's what I'm trying to get at. I understand impeachment. I understand impeachment of credibility, and if that was the rationale, if we assume materiality, and he denies being gay, and we assume probativity, that this evidence is somehow illustrative of the opposite point. I get that. Impeachment is a pretty broad door, as my colleagues indicated on their questioning of your opposing counsel. But if rebuttal evidence has to be relevant, that includes materiality, and I don't understand how any of this is material to your case.
Going back to law school, I always had issues with sometimes circular arguments involving materiality and relevance, because it would be relevant evidence is evidence that is material. Material evidence is evidence that is relevant. It always seemed to be, I guess I'm viewing it as it was relevant on the issue of he spoke from the stand that he was not gay and he was in possession of homosexual pornography.
But my question is different. My question is, what does his sexual orientation have to do with your case?
Whether he was
you have to
whether the rest of the statements that he gave under oath were reliable, whether the jury could rely upon his testimony.
That's a credibility issue. So now you're making a credibility. Okay.
Yes.
All right.
Maybe an example would be if in the opening statement defense counsel had said it may come out in trial that my client is a Rotarian. No, he's not. And then there is evidence coming in to say that even though he denies being a Rotarian, yes, he was. Maybe Justice Breyer's point is, so what if he's a Rotarian or not? What does it have to do with the facts of this case?
Let's do with whether he's testifying truthfully.
Okay.
So it does credibility.
That's where we are.
That's different. That's what I was trying to get to. Because I don't see any other kinds of material fact, an issue here. I just don't see it.
I can, there have been many times I've been accused of not closing my mouth when I should, and then in State versus Corbett, I stood before you on the issue of demonstrative silence and whether I should have opened my mouth instead of keeping it closed. I'll just rest on the fact that the Supreme Court has made it abundantly clear that they don't feel there is a connection between somebody charged with a child sex crime and somebody who then possesses child pornography showing sexual acts with children.
We're not talking about child pornography here, though. We're just talking about what you called him. I mean, for whatever reason, you all made that stipulation.
But taking it to the next level, him saying that he was not gay and in possession of homosexual pornography depicting scenes involving gay sex, to me is. I understand the Supreme Court says it's not. That's why I did not raise it in the case in chief. It was raised on rebuttal after the defendant said that solely for credibility purposes. It was not designed. If it were designed to establish a fact or prove my case through some ulterior motive, I would have asked the court, which had already given me permission, to go ahead and introduce the evidence that involved child sex pornography. That's not what the state did. We tried to stay as far away from that issue as we could. So hopefully that can establish our motives when we introduced it was to impeach his credibility on the stand. If you can't believe this point, then can you believe this point and this point and this point?
Right. And then you're in a lot broader field. Okay. Do you want to address prejudice?
You mean harmless error?
Harmlessness, excuse me. Yeah.
Well, obviously, I think it was said by Justice Rosen. Probably the most damning evidence in this case was a telephone conversation.
But you've already impeached his credibility, so
Well, we don't know that. I mean, that's up to the jury to decide. We maybe put a dent in it, but you don't know whether you actually pierced it or not. But the strongest evidence was that tape, in which he described, you were too young for us to do it. I think it was the big thing. What was it? I'll go to prison if they find out about it for the rest of my life. We shouldn't have done it. He never came out and specifically discussed what it was, but that was something we left to the jury, and it was pretty obvious it wasn't out catching snakes in the yard or something. So I think that was the most damning evidence, even despite this. If the court were somehow to find that the judge abused his discretion in allowing this. And keep in mind, the judge said that we could bring in much more than we did bring in. But if there's an abuse of discretion to allow this in, then there was sufficient evidence whereby the defendant could be found guilty, regardless of it's harmless.
I'm curious, was there a motion in limine filed in this case about this whole issue?
I'm not as prepared for that as I should be today. My recollection is yes. There was. That's my recollection. And maybe it was a gentleman's agreement between defense counsel and I. I'm not going there, okay, I won't file the motion. This topic was certainly breached. There have been other cases in which I brought in evidence of photographs involving children in these type of actions. I knew there had been changes in this court's rulings on the admissibility of that evidence and the propriety of that evidence.
But something led defense counsel to make the remark in opening statement about the issue of being gay. So is that something that person just anticipated, or something that you tipped them off you were going to be pursuing? Or I'm just kind of curious how this whole thing arose.
My belief was that it was an immediate assault by the defense to say he did not touch this little boy because he's not gay. Only a gay person would touch a little boy. He's not gay, he's not gay, he's not gay was how we're going to start this off to begin with. And then we get into marital discord with the wife, and they fabricated this. And that was the defense, the way it raised its way through there. So that I don't recall, there was nothing that I'm aware of where they thought I was going to bring up the issue of him being gay.
Might have even been in a witness statement or something, maybe, from the wife.
I wasn't bringing in the evidence of the most damning evidence I had that would, I'm not saying that it proves he's gay, but the most damning evidence I have that would corroborate him being gay would have been the pornography. And we weren't bringing that in. Clearly, we stayed as far away from it, never mentioned it. Ultimately never brought in the child pornography, so just brought in evidence of it being pornography.
Thank you, counsel. I see you're out of time. Do we have any further questions?
I want to ask you a quick question. You mentioned up front that you had done the 6 other cases on the Freeman factors.
Well, they never were. I'm not sure they were the Freeman factors, but I'm talking about 6 other cases involving that were stated by defense counsel as being examples of cases in Reno County that have been prosecuted and that there were lesser sentences. The proportionality argument, they were saying these cases showed disproportionality.
Here's what I want to ask you. After this incident, assuming it took place, a neighbor walks in the house and says, you're going to ride your bicycle, you're never going to ride your bicycle through my garden again because I'm going to kill you, and shoots and kills this kid. And then they were both then subject, both this defendant and the cold-blooded killing neighbor are both sentenced to a hard 25 life sentence. They would be the same. Premeditated murder would be a hard 25, correct?
There's also the possibility of departure from Jessica's
Well,
law.
sure. There's the old 4643 had departure downward too. I'm talking about the normal sentence for both of them is a hard 25 life sentence, and
I'm not
one did an egregious act, the other one cold-blooded killer. Is that proportional that they would both get the same sentence?
The answer I'll give you is that's the legislature's decision to decide, and they've decided that.
No, it's not. If it's a constitutional challenge, proportionality, we've said under Section 9 is a topic, a constitutional topic, and the legislature doesn't get to construe the Kansas Constitution.
I guess my answer would be that in that situation, I would not treat the homicide proportionally to the sentence that Dean Boleyn got. I would seek the hard 50 or capital murder for the murder of a child. If that were the scenario, I would come at somebody with other provisions that would be more specific for those facts. I would not go for life sentence, that possibility of parole for 25 years. It would be a hard 50 or potentially capital murder.
Any further questions of counsel? We took a lot of your time with our questions. Would you like about 30 seconds to wrap things up, or are you satisfied with where you are?
I'm going to take my best advice and just sit down and be quiet. Thank you.
Very good. Thank you, counsel. You reserve 3 minutes for rebuttal.
Your Honor, I just had one procedural point I wanted to make, and on confirmation as I sat down, Justice Rosen, you asked me questions about harmless error, but you know what? I went back and read the state's blue brief, and they never said the words harmless error. They never made any argument that this error was harmless in their brief, and this court has made it clear that the state has a burden to show, if you would agree with us that there was error here, that they have the burden to show that it was harmless. And you have also made it clear that if a party has that burden and they don't do it in their brief, that issue is deemed abandoned. And so I absolutely think it would be procedurally improper for this court to consider harmless error on that issue.
Any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.